who is the Senior Research Fellow in Anglo-American Relations at the Heritage Foundation in Washington, D.C. It's a think tank, as I'm sure you all know. Ted received his PhD in history from Yale University in 1999 and is the author of a number of papers and articles on abuses of Interpol. So, Ted, your turn, please. Just both of them. Okay.
Thank you very much. My purpose in this paper is a simple one. It's to dispel a few common myths about Interpol and to explain Interpol's purpose, how it works in practice, and how Russia, though not only Russia, exploits its systems. At the end of my presentation, I'll make a few suggestions about the ways in which Interpol could be reformed that would limit the potential for abuse, but this is primarily a how paper, not, as one Russian once put it, a what should be done sort of paper. Let me begin by stating one fact bluntly. Unless you've spent some time studying Interpol, everything you think you know about Interpol is wrong. Without exception, every depiction of Interpol in the movies and on television that I have seen is incorrect. The error is this: Interpol is not an international police force. It is not a global FBI. It does not arrest people. It does not charge them with crimes. There is no such thing as an Interpol arrest warrant, though that error, at least, is merely an understandable exaggeration of a process that does actually exist. Interpol is more like a global bulletin board for the world's police forces. Every Interpol member nation, all 190 of them, essentially everyone but North Korea, has what's known as a National Central Bureau, an NCB. The NCB is the member nation's liaison with Interpol. The NCB is not Interpol's embassy to a nation. The NCB is national property. Its job is to serve as a single national point of contact between national, state, and local law enforcement agencies on the one hand, and Interpol on the other. It's the NCBs that have the job of supplying the material that Interpol puts on its bulletin board. Now, two kinds of things can go on the bulletin board, as you'll see from the summary of the three forms of Interpol communications that I've distributed. If you haven't received a handout, there's some copies on the chairs as you enter this room. First and most formally, there are various colored notices. The most important and by far the most commonly used of these are the red notices, which certify that a nation has a valid arrest or court order for a named individual, and that the nation in question will seek the extradition of that individual if she or he is apprehended. Loosely speaking, these are Interpol's wanted notices, but that's an inaccurate way of putting it. In reality, these are national wanted notices that, at the request of an NCB, Interpol puts on its board. The time it takes for Interpol to do this depends on the circumstances, but a red notice can be requested and posted in as little as 2 hours. In about half of Interpol's member nations, a red notice is the legal equivalent of a domestic arrest warrant. In other words, if you're subject to a red notice and you're in one of these nations, you can and you will be arrested on the strength of the red notice alone. It's not easy to evade a red notice, as an increasing number of nations scan your passport against various Interpol databases when you arrive at passport control. But importantly, no nation is compelled by membership in Interpol to take any action at all on the basis of any request made through Interpol. Nations that choose to treat Interpol notices as arrest warrants do this on a voluntary basis. All nations in Interpol remain entirely sovereign and participate in Interpol on a basis of sovereign equality. Second, Interpol transmits what are known as diffusions. These are electronic communications between Interpol's member nations using Interpol's systems. The advantage of a diffusion is that they are private. They are not available to the public. Red notices, by contrast, must be sent to all of Interpol's member nations. Now, of course, as noted on the handout, one member nation can also communicate directly with another member nation using an email system, and naturally, nations can and do talk to each other outside Interpol. The advantage of Interpol is that it's a structured, formal system. Interpol was founded in 1923, but was essentially reborn after 1945. Almost immediately became involved in a controversy about the political abuse of its systems when, in 1950, Czechoslovakian dissidents hijacked a plane and flew to West Germany, whereupon Interpol put out, at the request of the Czechoslovakian government, a red notice on the dissidents. As a result, FBI Director J. Edgar Hoover ordered the FBI to withdraw from Interpol's predecessor organization, the International Criminal Police Commission. The loss of U.S. membership was a disaster, and as a result, the Commission adopted a new constitution and the name of Interpol in 1956. The 1956 Constitution was significant in particular because of its Article 3, which forbids Interpol from, quote, undertaking any intervention or activities of a political, military, religious, or racial character, unquote. In other words, Interpol is supposed to be exclusively concerned with common law crimes, offenses recognized by all civilized societies. This distinction between common law crimes and political crimes is fundamentally important to Interpol, for the simple reason that unless all of Interpol's member nations agree to keep politics out of it, the organization will fall apart, just as it almost did after 1950. The problem, of course, is to make sure that politics really do stay out. Interpol has several mechanisms intended to ensure that they do, though none of them, in my view, are entirely effective. First, all Interpol member nations are bound to comply with Interpol's constitution and its rules on the processing of data. Second, when requesting a red notice, Interpol member nations must state that a valid arrest warrant exists for the named individual. Third, at least in theory, Interpol reviews all requests for a red notice for compliance with Interpol's rules before issuing a notice. Fourth, notices can be challenged in various ways by NCBs and individuals, most notably through the CCF, the Commission for the Control of Interpol's Files. So it wouldn't be fair to say that Interpol has done nothing to limit the possibility for abuse. Unfortunately, in my view, all of these measures are inadequate. One reason is that for many years, Interpol worked through a paper system. But as Interpol commendably modernized its communications in ways that made requesting a red notice easier, the number of notices requested and issued skyrocketed. In 1998, for example, Interpol issued fewer than 1,000 red notices. By 2011, it was issuing almost 8,000 annually. The number of diffusions jumped from under 2,000 in the year 2000 to over 15,000 by the year 2011. The old paper-based system, by its sheer inefficiency, offered some protection against abuse. The new electronic system, entirely unintentionally, actually facilitates abuse. Many of you, particularly in this audience, will be familiar with Herzen's prophecy from the 1950s that what he feared, the 1850s, that what he feared was Genghis Khan with the telegraph. Interpol is the telegraph. The result of the skyrocketing popularity of Interpol systems is that the volume of traffic that Interpol needs to examine in order to ensure compliance with its rules has grown to unmanageable levels. It's obvious that Interpol cannot meaningfully examine 8,000 red notices every single year. And in fact, Interpol has acknowledged that approximately 97% of all notice requests are not reviewed in depth before they're issued. What Interpol does is simply review to make sure that the requesting nation has filled out its own form correctly. Interpol doesn't even require nations to supply an actual arrest warrant for a named individual. All they have to do is say that an arrest warrant exists. In one sense, this is not a bug in the system. It's a feature of the system. After all, Interpol is based, as I mentioned earlier, on the sovereign equality of all of its member nations. So it has no basis for presuming that requests from Russia, for example, are likely to be more abusive than those from Canada. It has no basis for assuming that Iran is likely to be less law-abiding than the United States. When he was interviewed in 2011, Interpol's general counsel put it concisely, quote, "It's really tricky. You receive a request for a notice from a country where human rights are not respected. I would love to have only requests from Switzerland, but the world is not like that," unquote. Well, indeed it is not. In short, if you're a nation that wants to secure a red notice on an individual and you're unscrupulous, all you have to do is tell Interpol that you have a valid arrest warrant, accuse the individual of an offense, and you are quite likely to get a red notice. For the individual, as several of my fellow panelists know far better than I do, the consequences of this sort of politicized abuse can be extremely serious. First of all, nations can choose to have their red notices listed on Interpol's public database. This is one case where openness is not a virtue, because once a red notice goes online, it goes into the world search engines, which will then record that individual as a fugitive from justice. Paradoxically, in this case, abusive nations tend to prefer openness. Legitimate requests are more likely to be kept out of the public side of Interpol's database. And by the way, when you go to Interpol's site and look at the red notices listed, you're only seeing about 10% of Interpol's actual database. 90% of them are hidden from public view. But in some ways, this is the least of it. If you're subject to an Interpol red notice, you will almost certainly be detained for secondary interrogation when you cross into another nation. You may be arrested and held for an extended period of time, and you might even be extradited to the requesting nation. And while the U.S. will not extradite, public red notices also show up in the databases that banks, including U.S. banks, consult to ensure their compliance with Know Your Customer rules enacted after 9/11. The result is that if you're the subject of a red notice, your bank accounts are very likely to be closed, and you will, in fact, be ejected from the U.S. and world financial systems. In short, a red notice, especially a public red notice, prevents you from leading a normal life. And by the way, being an American offers no protection against any of these secondary effects. If you think you're safe because you're not Russian, you are very wrong. While it's true that there are ways of appealing a red notice, the fight is likely to be long, arduous, and unsuccessful. I could say a good deal on this subject, but the basic problem is that Interpol CCF handles the appeals, works slowly, operates on the presumption of national equality, which places the burden of proof on the complainant, and has established no case law, meaning that every complaint has to start from scratch. When you couple all this with the fact that battling Interpol requires expertise that is specialized, rare, and therefore expensive, you arrive at the conclusion that unless the complainant is rich, particularly prominent, or lucky, the red notice is unlikely to be withdrawn. Moreover, even if the complainant wins, Interpol has no reliable mechanism for ensuring that its member nations remove the now discredited red notice from nationally held databases. In other words, even a withdrawn red notice can linger like a ghost in the machine for years. Now, to its credit, Interpol has recently shown some awareness of these concerns, and its new Secretary General, Jürgen Stock from Germany, has shown a far greater willingness to engage with critics than his predecessor, Ron Noble, from the United States. It embarrasses me that the new Secretary General from Germany is better on this than the American, but facts are facts. I'd be willing to say more about what Interpol has done recently in an effort to address some of these concerns, but I fear that the fundamental problem remains. The volume of national requests is simply too large to be examined reliably and with any degree of credibility. And I fear that the abuse cases will continue, and current abuse cases are in fact grotesque. My fellow panelists can say more on this subject, but let me draw out a few cases, a few themes common to many abuse cases. First of all, I should point out that Russia is definitely not the only abuser of the Interpol system. I have been told privately that the most abusive nation, if measured by volume of abusive requests, is Venezuela. Iran and the Central Asian nations also have a very bad record. What most, if not all, of these nations have in common is that they are autocracies at best or dictatorships at worst. In other words, they're not law-abiding. Curiously, they also tend to have one more thing in common. They tend to be very good friends with Vladimir Putin's Russia. Second, I should address another argument, which is that Russia has criminals just like any other nation, and that ejecting Russia from Interpol will only make the problem of combating Russian criminality even worse by preventing it from cooperating with law enforcement organizations in other nations. My blunt response to that is that Russia does indeed have criminals, just like any other nation. Unfortunately, some of the biggest criminals in Russia live in the Kremlin, and they're the ones who control Russia's interactions with Interpol. On a more philosophical level, we should remember that Interpol is an organization with a clear purpose. Interpol's mission is not to facilitate the sharing of information on genuine criminals while allowing only a certain amount of abuse. It is to facilitate the sharing of information on genuine criminals, period, and not to allow any abuse. If one common theme is that the abusive nations are not law-abiding, another is that the abusive charges tend to focus on financial crimes. Again, my fellow panelists can address this in greater detail and in light of some painful personal experiences, but the reason why financial crimes are such excellent fodder for requests to Interpol is fairly obvious. Financial crimes are complicated, they are hard to disprove, and there is no body. After all, if a murder has been committed, there is usually a corpse. If money has been misappropriated, the only thing missing may be ones and zeros in a computer. The core problem with Interpol is that it's based on the assumption that, as sovereign nations, all of its members are equally competent, capable, and willing and able to comply with the requirements of Interpol's constitution and all other relevant Interpol regulations. This assumption, unfortunately, is untrue. And while Russia is far from the only abusive nation, Russia matters more than most because Russia is considerably more important and influential than, for example, Sri Lanka. Naturally, Russia is very assertive in its claims that it is a responsible member of Interpol. In late September, for example, the Russian NCB celebrated its 25th anniversary with the claim that, quote, in the first half of this year, Interpol officers managed to return to Russia for criminal prosecution more than 25 defendants, unquote. Now, I dare say that many of those defendants are indeed guilty. Unfortunately, I don't know which ones are guilty, and nothing about the Russian system today gives me confidence that it's going to find out. Now, what can be done about this? Under Interpol's own rules, there are many options open for preventing politicized abuse. Above all, persistently abusive nations can have their access to Interpol-maintained databases suspended. Although when asked about this option, former Secretary General Noble, the American, described it as, quote, one of the most dangerous proposals I have ever heard, unquote. I do have greater hopes for the new Secretary General, Stock, but in my view, we cannot rely on Interpol to reform itself. After all, Interpol is ultimately controlled by its own General Assembly, in which all 190 member nations are represented, and which is therefore not dominated by law-abiding democracies. In my view, the U.S. should take more assertive steps, which under Interpol's rules it is entirely within its rights to take, to defend its own citizens when they are targeted by politicized notices. It should announce a formal policy of refusing to act on Interpol notices or diffusions from nations such as Iran, Sudan, and Syria, which the U.S. already bars from accessing U.S.-supplied data through Interpol. Finally, the U.S. should encourage Interpol and its CCF to be more open, always bearing in mind the rights of the accused, the potential for abuse, and the need for secrecy in pursuing genuine fugitives, and seek to build support within Interpol for applying Interpol's own rules, allowing the suspension of persistently abusive nations. Now, of course, that's not all I would want to do, and I would not want to place the blame, the burden of securing the reform of Interpol on the shoulders of the U.S. alone. Interpol has a profound responsibility in this regard. The alternative to reform, or to put it more accurately, the alternative to Interpol following its own rules, because that is all anyone is calling for, is that there will be more cases of abuse, like those suffered by several of my fellow panelists. Moreover, someday, Interpol will by chance facilitate the abuse of a palpably innocent person who happens to be exceptionally media-friendly. Unless Interpol can show that it is serious about applying its own rules, Interpol will then suffer at the hands of the U.S. Congress, which pays 15% and rising of Interpol's budget. In short, if Interpol does not remedy Russian abuse, and not only Russian abuse, of its systems, it will eventually be abused by the U.S. Congress. And unfortunately, Interpol will thoroughly deserve that form of abuse. Thanks very much.
Thank you, Ted. Thank you very much. Okay, let me introduce our second presenter. It is Kamila Mehtiyeva from Paris, and she is an advocate, a lawyer, attorney from Paris. She's also a PhD candidate at Sorbonne University. Her thesis is the notion of judicial cooperation. Previously, Kamila had got a law degree from Sorbonne University, specialized in criminal law and criminal procedure. More importantly, Kamila 5 years worked as associate of international law firm Sherman Sterling, and she worked on several arbitration cases, including the one very important and the historic one, the case of UCA's shareholders against Russian Federation, which was a year ago completed at the Hague arbitration, permanent arbitration court. And that's the historic largest amount of arbitration award issued ever, $50 billion, and the law firm Sherman Sterling is now enforcing this for the shareholders. Kamila also is the professor's assistant at Sorbonne Law School, and she is teaching contract law, civil litigation, and criminal procedure. So, Kamila, you're very welcome. Let's just move the...
Thank you, Pavel. Good afternoon, ladies and gentlemen, dear colleagues. There is an old saying that power corrupts, and absolute power corrupts absolutely. Unfortunately, this saying has proved to be fatally applicable to Interpol. There has been an emerging consensus within the international community that some totalitarian states have been misusing or abusing of law enforcement powers in order to revenge or to suppress their political rivals. The concern about the political abuse of the Red Notices have been raised for many years by important actors on international arenas, such as the European Commission, European Parliament, the Parliamentary Assembly of the Council of Europe, the Organization for Security and Cooperation in Europe, as well as the United Nations High Commissioner for Refugees. This concern has been raised by many international human rights organizations like Fair Trials, present in this room, as well as practitioners like we are. Some people who may be also present in this room have been direct victims of Interpol abuse. This is quite ironic because the most important document of Interpol, which is its constitution, explicitly forbids Interpol to carry out any activity of political character, and this is Article 3 of Interpol's constitution. How come that we have achieved this situation where the practice is so corrupt in relation to this major document of Interpol that has been so protective and has been preventive of any political intervention of Interpol? The difficulty is the following. How can one determine that a red notice that is issued by Interpol is politically abusive or is a lawful exercise of a state's powers to persecute someone who is researched in the country, who is wanted in that country? I will address this difficulty in a chronological way, in a chronological manner, by drawing a line between a preliminary control of the red notice request by Interpol, which is a prima facie control, and if that control fails, and as the practice shows it often does, the posterior control, the control that must be put in place, at least theoretically, by Interpol once the red notice is issued and its political character is claimed by the person who is wanted. So to start by the prevention of the abuse, The idea of a preliminary analysis of lawfulness of a red notice by an NCB, a National Central Bureau, refers to a filter, and that preliminary filter exists within the rules of Interpol. Where can we find this preliminary filter, and how is it implemented in practice? On what is it based? The key word to this question, the key word in the preliminary control is the purpose of the red notice. The purpose of the red notice is quite important, as you can find it throughout all the rules, all the legal materials of Interpol. I will start with the Interpol Rules of Data Processing. It is Article 10, Paragraph 1 of Interpol's Rules of Data Processing. And I quote, Article 10, Paragraph 1 provides that the processing of data in the Interpol information system may only be carried out for a given explicit purpose which is in conformity with the organization's aims and activities. This article carries on and puts the responsibility to determine the purpose of the processing of data on National Central Bureau on one hand and on General Secretariat on the other hand. Moreover, Article 74, Paragraph 2.a of Interpol Rules of Data Processing says that the General Secretariat is responsible for checking the compliance of all notice requests with the present rules, and Article 10, Paragraph 4 completes this requirement by saying that the General Secretariat shall put in place mechanisms and tools to guarantee compliance with the said purpose at all times. The purpose of international police cooperation, which is the purpose of the Red Notice, is explicitly emphasized in Article 77, Paragraph 2.b of the International Rules of Data Processing, which says that the publication of the notice, if the publication of the notice is not of interest for the purposes of international police cooperation, the General Secretariat may not publish that notice. And finally, to finish with this normative body of rules that emphasize the importance of the purpose of the Red Notice, I will quote Article 82 of the International Rules of Data Processing, according to which Red Notices are published at the request of an NCB in order to seek the location of a wanted person, to arrest or restrict his movement for the purpose of extradition, surrender, or similar lawful action. So, whilst Interpol legal documents establish minimum criteria that need to be met for a red notice to be published, such as serious ordinary crime, penalty threshold, etc., the Interpol's rules are totally silent as to the test that Interpol shall apply in order to see if the red notice is abusive or, on the contrary, is in conformity with its rules, including with Article 3 of its Constitution. Thus, it is very much unclear what test does Interpol in fact apply in practice. There has been some doctrine, some scholars who have pointed out on the fact that the difficulty comes from the fact that the threshold used by Interpol is much higher than the threshold that is used by national courts or international jurisdictions like European Court of Human Rights. I must say that I quite disagree with this opinion, because there are no reasons to presume that the threshold that is used by Interpol to appreciate, to evaluate the political character of the Red Notice, we have no indication as to that threshold. So there are no reasons to believe that the threshold is higher or lower or is the same. And to avoid any speculation, I would just say that the only thing that we know about the test that Interpol applies is the very poor information that results from the letters that the Commission for Control of Interpol's Files, the CCF, sends to lawyers once they file the request on behalf of their clients, claiming that there is an abuse, that this is political. And the CCF tends to reply that it is satisfied or unsatisfied about the predominantly political test. So the only thing that we know about the criteria that are used by the CCF Commission is this mysterious predominantly political character. But once again, to avoid any speculation, it does not seem to me that the predominantly political character is more severe than the political offense that is used by courts, by national courts, or by ECHR, the European Court of Human Rights, for example. So to put away this test about which we don't know much, I would say that the problem comes not from the substance of the test, but from the method, the way that this test is applied. And I think that is where the deficiency and the flaws come from. The underlying reason for this deficiency, I think, is much deeper than just the political game. It is the entire ideology of the system, the ideology of the Interpol system that relies upon the faith in the good intentions of the state. And as my colleague Ted just highlighted, and I very much agree with this expression, he said that there is a presumption of national quality of justice, I think of national quality of the requesting state. There is indeed this presumption, the belief that a requesting state that sends a request does it with a good intention. Indeed, this presumption of good faith has created this major loophole in the system of Interpol, from which the totalitarian states have been benefiting and have used in order to transform the police cooperation into their preferred tool to fetch the political rivals. The question is then, once the harm is done, how to remedy the harm? And this brings me to the second part of my analysis, which is how to remedy once the red notice is issued. I will go back again to the foundation of Interpol and its core legal documents, and I will quote another article, Article 81, Paragraph 2 of the Interpol Rules of Processing of Data. And the Article 81, Paragraph 2, once again goes back to the purpose of Interpol's red notice. Article 82, Paragraph 2 explicitly states that an NCB shall withdraw its cooperation request and ask the General Secretariat to cancel the notice immediately once the purpose of this request has been achieved. And if the National Central Bureau fails to ask to withdraw the red notice, then Article 81, Paragraph 3 requires the General Secretariat to do so if it considers that the purpose of the cooperation request, on the basis of which the notice was published, has been achieved, or if the notice no longer meets the conditions for publishing. So once again we go back to this important key issue, which is the purpose. And now we know that the criteria for the publication or for the withdrawal, so for the remedy, is to consider whether it has been achieved or not. Now, if the General Secretariat or the NCB fail to do so, and as I already said, in practice, they almost all the time they fail to do so, the only remedy that is left on the basis of Article 36 of the Constitution of Interpol is the CCF, the Commission for Control of Interpol's Files. However, most of the people present here know that in practice, arguing the political context of the case has been insufficient to convince the Commission of the abusive character of the red notice. Convincing the CCF being a very hard task, that made me think of other remedies we may seek in order to withdraw, to make the CCF withdraw the red notice. And once again, I think the reason for the CCF to be quite reluctant to give this subjective appreciation of the political character goes back to the increasing need to fight terrorism. And there has definitely been a severe movement on behalf of the CCF after September 11 events. Unfortunately, the recent events in Paris also show that fighting terrorism is still a problem, and every state is concerned, and everyone needs to put common efforts to cooperate and to fight against the terrorism for everyone's security. So Interpol's mission, which totally relies on member states' goodwill to cooperate, has been sort of stopped or slowed down by this necessity to cooperate in very severe, very grave matters like terrorism. So Interpol, for diplomatic reasons, has definitely been very reluctant, and I may say also hypocritical, and hence reluctant to give any subjective appreciation of the political nature of the cases, which pushed me to analyze the situation and suggest a more, I would say, objective argument or a technical argument, which is the achievement of the purpose. So Article 82 of the Interpol rules says that the purpose of a red notice is to arrest the person in order to extradite him. This means that the red notice is inescapably a part of extradition proceedings. And not only is it a part of extradition proceedings, it is also a tool, a mean to achieve a goal. So the red notice is not a goal in itself, it is a mean to achieve a goal, which is an extradition. So if the red notice allowed her to locate the person and to arrest him, this triggered the beginning of the judicial dialogue, and the judicial dialogue is exactly what extradition is. No matter if extradition was achieved or denied, the mere fact that the extradition has started means that the dialogue has been successful. And this should be the way the red notice is analyzed. The red notice achieves its purpose from the moment a person is located, a person is surrendered, and his extradition request starts in the country that has accepted the request to extradite. Because once again, it is the extradition that is the purpose, that is the ultimate goal, and not the red notice, which is just a mean to achieve that goal. If we do not think it this way, we see how inconsistent the system is. Because the ultimate goal is impossible, because one country has decided that the extradition is dangerous for the person, and he will not face the guarantees of fair trial in the country where he is extradited. So the extradition will never be achieved, and the red notice, which is the mean to achieve this goal, is still maintained. However, we see that this has not totally convinced the CCF yet, although based on my practice, which I'll be very happy to share with you in a moment, it has shown some progress. So based on my practice, I will give you two scenarios, and I think it is very important to draw a line between these two scenarios. The first scenario is the classical one, when a person crosses a country, a frontier, comes to a country, is arrested based on the red notice, and then stays the delay that is necessary for a country to receive the extradition request. Usually it is between 40 and 80 days, depending on the national legislation. I am actually defending a client before the CCF who is a former Russian Duma deputy, and I will not disclose his identity because the case is still pending. But I can tell you that the Russian Federation filed a request against him a few years ago, and he went to a third country where he got established with his family. And then as he went to a vacation for a few days to another country, thinking that nothing would happen, the red notice alert was flagged by the authorities as he was crossing the border, and he stayed for 50 days in a local prison. After that, there was a request that was sent and was rejected on a very firm basis that there are strong political grounds and he may not be extradited to the Russian Federation. The person went back to his new country of residence, and never took any risk to travel anymore, which has been more than 10 years now. I filed a request a few months ago, and we are expecting, I hope, a positive answer, because the reasoning that I use is the one that I just told you about, which is the purpose has been achieved, and there are strong grounds to believe that the decision of this court, national court, that rejected his extradition request based on political grounds, will be universally admitted. A, it will be admitted in the European Union because it was a European country, and B, it will be generally admitted because if one country thinks that this is a strongly political case, there are strong reasons to believe that another country will also decide so. And in any event, the red notice has achieved its purpose, so there is no reason to keep the person in the database. Because the main issue that the Interpol needs to decide here is the following: isn't the fact that the person's extradition has been rejected, isn't this fact the ultimate proof of the abuse? The second scenario, which I can tell you about, is the same case But we add another element to the person's personal situation, is the asylum. I have recently prevailed in a case for a client who has been in the Interpol's database for 11 years, and I defended that person before the CCF. We recently got a favorable response, and her information, it's a lady, her information was removed from Interpol. Her extradition was sought by the Russian Federation in the UK, where she has a permanent residence. The United Kingdom denied the extradition by saying the following, I quote, "In respect of this particular case, I'm satisfied that it is so politically motivated that there is a substantial risk that the judges of the Moscow City Court would succumb to political interference in a way which would call into question their independence." A few lines later, the UK magistrate courts stated that, "For the reasons I have just given, I am satisfied that extradition in this case is barred under the UK law, in that the request for extradition is made for the purpose of prosecuting the person on account of its political opinions." Just a few months later, this person got a political asylum on behalf of the UK authorities. When I filed the case before the CCF, I mainly argued the non-refoulement principle. The non-refoulement is a very important principle of international law, which is the prohibition to return a person in any manner whatsoever to a country where the person faces a prosecution and because of which the person received a status of political refugee. This principle of non-refoulement has received a real promotion for the past, I would say, 20-30 years. The promotion it's a very common way of saying that, but it has crystallized into a real rule of customary international law. And by being a rule of customary international law, it applies to everyone, including international organizations, which Interpol is. The important move in the value of the non-refoulement principle has been played by the European Court of Human Rights. As you may know, the European Convention of Human Rights does not protect refugees. It is the Geneva Convention that does. But the European Court of Human Rights has integrated the non-refoulement principle into the scope of European Convention by under the cover of other principles that are protected, namely Article 3 of the Convention that prohibits torture and cruel treatment. For your interest, if you are interested, it is a landmark decision of July 7, 1989, which is ECHR decision Soering versus the United Kingdom. In the landmark decision of 1989, the ECHR held the UK liable for having violated the principle of non-refoulement because of the extradition of the refugee to a country because of which the person received the status of asylum. And the violation of this non-refoulement was based on Article 3 of the Convention, which is the prohibition of cruel treatment. Later on, the ECHR developed its case law by expanding the protection of the non-refoulement principle under the cover of Article 6 of the Convention, which is the right to a fair trial, and very recently, quite recently, I would say, it's been 10 years now, 2004, which is also a case against the UK, F. versus the UK, it's June 22, 2004 decision. The ECHR has rendered a very important decision by consecrating an obligation to guarantee the integrity of refugees. And the way it did it is under Article 1 of the European Convention of Human Rights. And Article 1 of European Convention guarantees the integrities of people not only on the countries, on the territory of the state, but also on the territory of the state where the person is extradited. So the ECHR is willing to hold countries liable for extraditing refugees to the state where they may face persecution. So this quite solid argument, I would say, has probably convinced the CCF more than just the purpose, and we can definitely say that there have been some positive moves, some good winds of change for those who have a political asylum. I'm persuaded that by keeping the CCF convinced and reminding them of the spirit of its rules, of the spirit of the cooperation, which must be done in conformity with the Universal Declaration of Human Rights, we shall stay optimistic, and we may pursue what we do every day by fighting the abusive red notices, by convincing Interpol that the ultimate proof of the abusive nature of the red notice is the denial of extradition request by one state on the basis of a risk to the integrity of a person. So we can only hope that good winds of change will start blowing and will blow stronger, and the legal value, the legal authority of judgments, the res judicata of a judgment that denies extradition will prevail over the request of totalitarian states to issue the red notices. Thank you for your attention.
Kamila, and let me introduce our third presenter. It's Alexander Smoljanski. He is the head of research of the Integrum Worldwide. Alexander was born in St. Petersburg and graduated from the St. Petersburg Aviation Academy and from the St. Petersburg School of Foreign Languages. He worked in the 80s as a translator of British and American literature. And since 1999, Alexander has been working in Integrum Worldwide, which is the information agency researching mass media and social networks of Russia and other post-Soviet countries. Alexander's research interest of the last several years is how political and social changes in Russia and the former Soviet Union countries are reflected in mass media and social networks. Alexander, please.
Thank you, Pavel. First of all, a little disclaimer. Contrary to my fellow panelists, I'm not an expert in Interpol at all. So if I do any mistake, please don't pay too much attention to that. And so what I'm going to say is, and to show, is just to show how Interpol as such is reflected in Russian mass media and in Russian social networks, and just try to check if the topic is really hot or not. If it really draws any interest of the readers of newspapers, of the users of social networks. And the research is done with the database called Integrum. And what Integrum does is the building up a sort of electronic portrait of the former USSR. So thousands and thousands of newspapers, magazines, archive over the last 25 years are stored on the servers, and billions of posts in social networks are monitored according to the topics which are interested to the researcher. And now what we're going to do to see how Interpol topic can be researched using this research tool. So altogether, what we are going to use is this service which is called Integrum Profi, and this is the world's largest electronic archive of all mass media of the former USSR countries. And this is this one, the first one. I'm using iPhone for this presentation, so I cannot point the mouse pointer. Sorry for that. The second one is My Integrum, and what is that? You can set up the topic of monitoring, and the system 24/7 monitors the whole post-Soviet information space according to the topic of your interest, and withdraws the articles and any other materials which are relevant to your search criterions, and gives you the instruments for the analysis. The third one is Integrum Social Networks, and as I said, this is quite an effective tool to research how the topic of your interest is mirrored in social networks. So first of all, This is Integrum Profi, and this is some statistic of that. And the archives going back to 25 years. The documents are in Russian, Ukrainian, and English. And let's just enter this research word, Interpol or Interpol in English. And let's limit our research only in the last 12 months. So as you see, it's just 10 years. It's from 2005 until 2015. And as you see, the system shows first, and this is on the left-hand side, the overall picture, how Interpol is reflected in all post-Soviet media over the last 10 years. So you can easily see in what groups of mass media Interpol is more or less active, mirrored. On the right, there is a table which shows specifically from what publication go these materials, go these documents. So you can immediately see what newspapers and magazines are most active in reporting the issues regarding Interpol. So altogether, as you see, 250,000 documents related to Interpol are found in the last 10 years. So, is it much or not? To answer this question, let's just compare how two other international organizations are mirrored in, or represented in Russian in Russian mass media. So, let's take NATO, for example. As you see, 2,235,000 articles are related to to NATO. Let's take another international organization, European Court on Human Rights, and as you see, it is 342,000. So all of this is way, way more than Interpol. So this is the first thing which I wanted to show you, just to understand how popular it is. It's not particularly popular. Now let's see the dynamics. What our system does, it shows you the intensivity of mentioning Interpol in post-Soviet information space. So you see, in the lower part of the screen, there are the years. And as you see, there are some years, for example, 2014, when the representation of Interpol was quite bigger than the average level of the last years. But most of the years from 2005 until 2013, the level is quite low. Now, let's take the most vocal, most famous cases. This is, I don't want to read it once again, you can easily read it. So let's take just a couple of people with some comments. The last two cases were put forward not by Russia, but by the Ukraine and Georgia, respectively. So, let's take the first three cases and see what are the contexts from mass media. You see in what context these people are mentioned in regard to Interpol. Once again, I don't want to read it aloud, it's quite visible. Of course, you can click and have the full issue, the full text of the document. These are the next three people with some notes on the people themselves and with the quotes from mass media. So you once again immediately see the context. Now let's compare the quantity of the articles regarding or mentioning each of these people over the last 12 months, even more than 12. So as you see, Mr. Yanukovych is by far the leader of mentioning in regard to Interpol in Russian mass media. So I don't want to comment in details because everything is quite visible and self-explaining. So these are the figures which the system generates automatically for the research purposes. So and you see quite a lot of zeros. It means for the whole month, not a single mass media title. Out of thousands and thousands of newspapers and magazines, TV and radio stations ever mentioned this or that person in regard to Interpol. Now let's switch to integral social networks. And as you see, this is 24/7 monitoring. You can easily set up your own topic. It could be somebody's name or the name of the company or just any combination of any words. And the system will pick up all the posts in social networks in regard to this. So this is the context. Once again, I don't want to read it aloud. I don't know whether you can read it or not, or they're maybe too small, but it's quite interesting to see the context in social networks, what the bloggers, the users of social networks say about particular cases in regard to Interpol. So you can see the full text of the post. You just click and it's opened. And once again, I just wanted to compare the number of or intensivity of discussion in social networks, different international organizations, Interpol, NATO, and European Court on Human Rights. So, as you see, Interpol is 3,000 plus, NATO is 71,000, and European Court of Human Rights is almost 9,000. So the same tendency in social networks, once again, the Interpol cases don't ignite fierce discussion. It's definitely on the third place in comparison with other two. So now let's see the comparison of all the posts in regard to Interpol and the posts where your people mentioned in the previous slides are mentioned in regard to Interpol. So as you see, definitely Mr. Saakashvili in social networks has position number 1 over Mr. Ponomarov, who is on the second position, and Mr. Yanukovych comes the third. This is month-by-month dynamics, which shows you how the intensivity of coverage of your topic is in social networks. And now you can even apply filters. You can see what women or what males and females write about your topic, what are the people of certain age are writing, what are the people from certain areas, geographically specific, and what are the posts on different languages. And as you see, the most useful or used, I would say, platform in the internet regarding these post-Soviet cases in regard to internet is by far Vkontakte. So my advice to you, if you're going to research social networks, don't lose your precious time on Twitter and Facebook, which are sheerly just irrelevant. Most of these discussions are on on Kontakte platform, 58%. So more than all other, put together. So, and these are the countries of the world. So you see now how all these cases are discussed in different countries of the world in Russian language, of course. So as you see, and this is a legend on the upper left corner. So I think there is no need to comment. You immediately see the most active regions in regard to Interpol. And this is Russia with all regions, subjects of federation. So once again, you see that, to my dismay, by far, the most active region where these cases of these 6 people mentioned above is St. Petersburg, not Moscow. By far. About 70% lead. I didn't expect it, to be honest, when I started the search. So, and these are some conclusions. Once again, I don't want to read it aloud, just read it through, and by doing this, we're going to save time.
Thank you, Alexander. Thank you to all presenters. We're now coming to a more interesting part, I believe. I'm joking, of course. So let me introduce our discussant, who will give his comments first to the presentations, and then, of course, we'll have time to discuss it for the all present here. Our discussant is Ilya Katsnelson, who is a Jewish-American businessman permanently residing in Denmark. Ilya immigrated twice in his life, the first time as a refugee from the Soviet Union fleeing anti-Semitism at the age of 10, and the second time to Denmark with his wife and son at the age of 25. And over the past 30 years, he has become a successful businessman doing business in Denmark and United States. From 1992 until 2005, his main activity was in the Russian market. So at this period of time, and especially from 2000 to 2005, he worked with Volga Tanker, which was at the time the world's largest river shipping company. And Volga Tanker worked in the close association with Mikhail Khodorkovsky's Yukos oil company. And as a result of that, as all of you know, of course, the Yukos story, as a result, Volga Tanker and Ilya personally became a target of the Russian authorities who expropriated Volga Tanker. And for the second time in his life, Ilya became a victim of Russian state persecution. He was placed on the Interpol database, and a red notice was issued on his person. Over the course of the last 10 years, past 10 years, Ilya has become an outspoken critic of the Putin regime, taking every opportunity to educate the Western public about the true nature of the kleptocracy running the Russian state. So, Ilya, please ask your questions or comments, please.
Thank you very much. Actually, sitting here, I'm envious. I'm envious of this audience because you, ladies and gentlemen, have had an opportunity during a period of about an hour to get a contextual overview of a subject that took me about 10 years to learn. I mean, the research that has been presented by my fellow panelists, Ted and Kamila, are just outstanding. The only thing I can add is some personal insights. So what I would like to do is ask some questions, sort of leading questions, to help add context to the subject. Now, Kamila, you mentioned the concept of non-refoulement, the Geneva Refugee Convention. It seems to me that there's a difference between an individual who, like myself, an American citizen who could never get a refugee status around the world, because I certainly don't want refuge from America, So in a way, having an American passport is a disadvantage for me. So when you have an individual who has gotten asylum, as you mentioned, some of your clients in UK and in a third country, if they were to become a citizen of that country, how would their status be different vis-a-vis an Interpol Red Notice and extradition?
Thank you, Ilya. This is actually a very acute and very important question that has been raised on a number of occasions for the last few years in my practice. I wouldn't say that being a U.S. citizen is a disadvantage. I think everyone would agree with me that it is not a disadvantage. I would, however, say that even being a European citizen has turned to be, if not a disadvantage, at least there was a certain discrimination in treatment in relation to this to Interpol regime, Interpol Red Notices. For those who have become the EU or US citizens, and those who have acquired a refugee status, I had a very recent case of a person who has acquired the French nationality. I was representing him before the CCF and before the French criminal court. His name is Mr. Nikolai Koblakov, and he's a Russian guy who also obtained a French citizenship a few years ago, and he never thought he would have problems with the justice, but he created an NGO which is called the Russie Liberté in Paris, and for somehow he displeased to the authorities, and one day they knocked on his door, the French authorities knocked on his door, and he was taken to the police station, and that's how his problems started. And when they called me from the station and I came to see him, he told me, but I'm safe, right? Because I'm a French citizen and French does not extradite nationals. And I said, well, what year were you naturalized? And he said, well, 2 years ago or something. And I said, well, I think the Russians know quite well, the extradition law in France, because France does not extradite its nationals, but it does unless the person was naturalized after the events that were allegedly committed. And so he was not covered by this protection. Eventually, ultimately we prevailed and the extradition request was denied. But he asked me, what can I drop my citizenship and ask an asylum? And I said, no, because there is another hurdle in that. You cannot ask for an asylum because you can legitimately ask for an asylum if you really don't have any other protection. So if you don't have any other place to go to, but if you have a citizenship, then you have to, EU or US, you have to trust the justice and just believe that, hope that it's going to resolve the problem in a lucid way and decide that your extradition request is indeed politically motivated. So there is not a disadvantage, but definitely discrimination and a discrepancy between the two systems. So no refoulement protects the refugees, but those who may not be refugees, they definitely have it's very slippery for them. So there is this issue that has been, we have started, a few practitioners, including myself, we have highlighted this problem in the European Parliament a few months ago, but there is no solution to this problem because it would be inconsistent with immigration law in the EU. But there is definitely a problem for those who are threatened by the Red Notice. Mm. Yeah.
Thank you very much. I think it's interesting in the context of the world today to find a situation where being a refugee can be an advantage over a national, European national. Ted, I listened very carefully to your report. I found it extremely interesting. You mentioned something that for me touched a raw nerve, that a lot of things, of course, and that is the fact that the arrest order or the Red Notice is not the only consequence, of course, of somebody being politically persecuted, pursued by Russia, in my example, but also the fact that bank accounts get closed, which happened to me with the U.S. bank. I won't mention it, but it is Citibank. And other consequences. You also mentioned the know your client or know your customer rules, the NYC requirements for compliance for financial institutions, attorneys, and auditors. In your research, did you find that Interpol is aware of the consequences of this? And how are they dealing with it?
There are a number of interesting questions surrounding this, and I should say that for folks who want to pursue this in a little bit more detail, my remarks formally today were based on a relatively longer piece that I published in a U.S. political magazine, The Weekly Standard, in the March 2, 2005 edition titled Putin's Long Arm, How Russia Uses Interpol to Harass Opponents, and that's publicly available if you want to read the entire thing. Does Interpol know what's going on? I think there are a number of levels of relative ignorance about this. First, it's not always clear that even the Russian authorities are fully aware of all of the secondary effects of Interpol Red Notices, although by this point I suspect that they're pretty well aware that Red Notices can have the effect of ejecting you from the financial system. I'm almost certainly, I'm almost certain of the fact that U.S. banks and the specialist U.S. and international firms that scan databases in which the Interpol Red Notices are picked up aren't really aware of how the Interpol system actually works. All they know is that there's a red notice, they found it, and therefore they have to act. They don't know the circumstances behind it, and I think they're not interested in knowing the circumstances behind it. The specialist firms that do this kind of research are, in my experience, unaware that they're not even seeing the full Interpol database. They think the public database is the database. They're not aware that 90% of it is hidden. So they're relatively ignorant as well. Does Interpol know? Interpol cannot, by this point, be unaware of all the reports that have been circulating, certainly not limited to my own work on this subject. But I would say that in some respects, Interpol is not responsible for the way that red notices and other forms of communication are taken and used by other people. What they're responsible for doing is making sure that they issue only notices and allow the transmission of diffusions that comply with their rules. That's the fundamental problem. The problem is not for Interpol to remedy that U.S. Know your customer laws have a curious interaction with the world's financial systems. That's a problem for the U.S. Treasury, the U.S. Congress, the U.S. NCB, and other authorities, certainly not limited entirely to the United States. If Interpol policed its own publications, its own transmissions more effectively, then none of this would be a problem. In the current state of affairs, it's primarily a U.S. but also a UK and other national authority problem. I guess maybe to sum it up, everyone needs to take care of their own area of responsibility and do their own duties in a professional and serious kind of way. And in that case, we'd have a lot fewer problems.
Thank you, Ted. I agree with almost everything you said, except the part about the Russians might not be aware of the consequences. I think we can all agree that the way they were so vociferously fighting against the Magnitsky Act, they realized that the consequences of them being blacklisted would be that they get a taste of their own medicine. So, and we can see how effective the sanctions have been against individuals, Russian individuals who've been placed on it. So I get a certain degree of satisfaction from that personally. But I'll come back with another question for you, Ted. You mentioned briefly, and I'm hoping you can elaborate on this, in regards to how the United States, our own NCB, our own Justice Department, can be helpful. You know, when an American gets captured somewhere in the Middle East or in the Horn of Africa, we send the 7th, or I think it's the 5th Fleet we send there. What is it that we can do here without sending an aircraft carrier group?
Well, there are actually a ream of things that the United States can do, and of course it depends very much where the individual is. If they're in the United States, the obvious point is that the U.S. is very unlikely to extradite to any of the abusive countries. Unlike France, the U.S. does extradite its nationals, and I have to say that I have no problem with that. If the American is arrested in a foreign country, it's primarily the responsibility of the State Department. to take action to protect that individual. There are a number of things that the U.S. can do. The most important of them, apart from, and at least one person on this panel will have personal experience with this, apart from actually contacting the arrested individual directly, the most important thing is for the USNCB, the National Central Bureau, to challenge the red notice that resulted in that person's arrest. That's an entirely standard Interpol procedure, and they're very well-worn ways for the U.S. and for any other country's NCB to issue a challenge. Now, there's a set of appeals procedures laid out in the Interpol rules on the processing of data and its constitution. Ultimately, the challenge could go as far as the Interpol General Assembly, that is the organization that ultimately controls Interpol of all Interpol member nations. It's unlikely, as a matter of practice, that it would get that far, in large part because the United States is the United States. And if it makes a well-founded protest against a red notice or a diffusion, it's reasonably likely to get its way. The difficulty is more that the USNCB views itself primarily as a law enforcement organization and has, and I would like to be charitable about this, has what is, I would loosely call a policeman's mentality, which, to be somewhat harsh, consists of saying that, well, at least 90% of them are almost certainly guilty, and hey, 10% ain't all that bad. So the USNCB is really not incentivized to go around challenging a whole heck of a lot of red notices because it's going to upset people. It's going to upset other nations. It's going to imperil U.S. cooperation with Interpol. In the worst circumstances, it might lead another nation to quit Interpol, and the U.S. is really not terribly interested in that. It's simply not in the NCB's mental framework to view itself as a defense advocate for people. It views itself as a cop. Its job is to get people arrested, get them extradited, and get them back to the United States. So the NCB has many things it can do, but it's not ultimately terribly interested in doing them. The most interesting case of this happened a few years ago when Egypt tried to issue red notices on a series of U.S. NGO workers. This was after the collapse of the Mubarak regime. Ultimately, the red notice requests were rejected thanks to strenuous U.S. intervention on the part of the NGO workers. The reason why, unfortunately, was that one of the NGO workers was the son of the U.S. Transportation Secretary. And you can imagine how this conversation went. The Transportation Secretary probably called the head of the U.S. NCB personally and said, "You do something. They're coming after my kid. You do something now." Well, I mean, that's an entirely natural reaction and you know, probably commendable. Unfortunately, not everyone is the son of the U.S. Transportation Secretary, and not everyone can place a call direct to the head of the USNCB and demand action on a personal basis. Unfortunately, that's the problem.
Well, clearly I was born into the wrong family. Otherwise I wouldn't have these problems. Kamila, I have a question for you because Ted just brought up an interesting point about procedures. And you mentioned in your report a number of laws, regulations, the charter of Interpol as an organization. But it seems to me, being a super sovereign or extra sovereign organization, there's really nobody there to keep their feet to the fire. Can you talk about what is it that forces them or not, or allows them to ignore their own rules? I find particularly amusing the concept of not predominantly politically motivated. I've heard of a concept being a little bit pregnant. You either are or you're not. So just as my own personal commentary.
Yeah, Ilya, your question is actually very good because it reflects an old saying, once again, or a joke, that the guards keep the order, but who keeps the guards? So they have put in place this entire police system which works quite well, but you know, these loopholes work very well as well, and no one is there to remedy. The question has been raised many times for the past decades, what you just mentioned. And the question is, who is there to control how the laws are enforced, has been allegedly remedied by Interpol a few years ago when they granted the Commission for Control of Interpol's files a new status. So it was a part of Interpol's organization, and a few years ago it became what Interpol calls an autonomous body. So it's an independent body within Interpol. So I don't quite get the difference, or the nuance how a body which is part of Interpol can be independent. Especially that nothing has really changed. It's not a judicial proceedings. A lawyer cannot plead before the commission. And most of all, the judgment, you cannot say that it's a judgment. A letter is never motivated. And I think the lack of motivation makes the system totally opaque, and you never know why you failed, why your request, which is based on a political predominant character or any other motivation, has been rejected. And the lack of any knowledge of what was behind the decision of the CCF makes the system completely dark, and there's there's nothing, no element that we can use to see, how it can be improved and why, and how these theoretical rules that seem to be perfectly consistent, who is there to enforce them. I should mention, though, that there has been a theoretical improvement in 2008 under the presidency of French former President Nicolas Sarkozy. In 2008, there has been a reform. You know that there is a headquarters agreement between Interpol and France, because Interpol is in Lyon. And the reason behind this reform was the following. Many scholars and international organizations have been discussing the fact that because Interpol is an international organization, it has an immunity, and you cannot challenge the acts of the international organization before the court, before the national courts. Now, in France, there have been some very creative plaintiffs that decided to file a request, and it was in 1980. It was before the first instance court, which is called Tribunal de Grande Instance in Nanterre, and it's an only decision that we have. The plaintiff said that because Interpol is in France, France should have jurisdiction, and the first instance tribunal said that it's an international organization, it's a sovereignty, we cannot review this act, so it cannot be challenged. This decision gave place to a lot of good writings in the area, and under the presidency of Sarkozy, there was a renewal of the headquarters agreement. And if you compare the old version and the new version, they're completely the same, save for one provision that was inserted into the 2008 agreement, which is a new remedy. They say if there is a conflict between the organization and the person, then the alternative rules of resolution that are that are drafted by the Permanent Arbitral Chamber of The Hague should be applicable. And if you go to those rules, you see that are referred to in the headquarters agreement. You see that it's actually a third party, a third member, a three-member, or a sole member, sole arbitrator proceedings that are put in place. For the moment, there has been no implementation of this article, of this provision. There has been no practice, no commentary, save for maybe one article of a French scholar. But we really don't know what it means, the conflict between a physical person and Interpol. But I suppose that having no answer, or a negative answer for a number of times on behalf of CCF may be interpreted as such. And I think, for instance, if some of my clients still get a refusal, we have an agreement that we should, maybe try to put in place an arbitration, or another remedy, maybe ECHR, but which goes to another reasoning, which is the lack of appeal of a decision or lack of motivation. Because even if CCF does not have a judicial nature of a body, it is still a body that decides. Right. So if it's not judicial, it's still an authority that has a power of decision making. So these are all exterior, actors and methods that have never been implemented. So that's all I can say about keeping the guards.
Well, it sounds to me like what Ted was talking about, this being a very, very expensive, arduous, and difficult process is absolutely correct. But I'd like to give Ted an opportunity to respond to this, because your expertise is international organizations. So.
Yeah, there are a lot of measures that you could take to guard the guards. Obviously, Fair Trials International, a representative here in the audience, has published an excellent report on this question. At the Heritage Foundation about 2 years ago, I also published a very long paper containing about 20 pages of possible, I hate to say remedies, but ameliorative measures that could be taken in this regard. The question of international organization privilege is interesting. What you might call a sort of nuclear weapon in all of this is that Interpol has received, through a 3-stage process in the United States, international organization immunities under the International Organizations Immunities Act. The first step came in 1983 under President Reagan. Reagan acted because Interpol was successfully sued in U.S. courts for publishing a false and defamatory blue notice, which is a slightly different kind of notice, against a U.S. citizen. U.S. citizen challenged this and won, thereby winning the right to sue Interpol for monetary damages. The U.S. then, over a series of years, gave Interpol, international organization, immunity so it couldn't be sued. The nuclear weapon in the United States is to partially or fully remove Interpol's immunity from legal prosecution as an international organization and make it subject to lawsuits for false libel or libelous notices or diffusions. That, I suspect, would be, first of all, difficult to achieve in the United States, but if it were achieved, it would almost certainly scare Interpol back onto the straight and narrow, because Interpol's budget is only about $90 million a year, and it would be bankrupted very fast by U.S. courts. Now, I'm not advocating that right now. I think there are lots of other things that can and should be done before you start deploying the nuclear weapon of removing Interpol's immunity from U.S. lawsuits. But if push came to shove and the situation got bad enough, that is the course down which I would go.
It's interesting that a representative of the Heritage Foundation just mentioned that Ronald Reagan started all this, right, with the immunity. But we can't all be perfect.
Even a great man makes a mistake now and then.
Naturally. Actually, not everything is so bad. I mean, what I've heard today and what I have been following is that things are improving. A number of people who have been unjustly placed on Interpol, especially people who are connected to UCAS, have recently, through the efforts of my fellow panelists and other attorneys, have been taken off Interpol. And I'd like to address the question to both my right and left. What do you think was the cause? Was it a cause célèbre, as you mentioned, possibly could have been? Or is it the combined efforts? I'll give you an opportunity to answer that, but I'd love to hear your opinion on it.
What is the cause of the, let's say, the hopeful improvements that we've seen?
You've mentioned that Jürgen Stock has taken a different approach than Ron Noble.
Well, I think there are a couple of factors. Media exposure is by far the most significant one. What really causes Interpol concern is what causes most organizations concern, which is bad publicity. And the case of Bill Browder in particular, if you haven't read Bill's book titled Red Notice, it's a really good read. The guy knows how to do a lot of things well, and one of them is right. So it's simply a fun book. His case has probably been the single most important case in drawing attention to Interpol. Other cases, including several of my fellow panelists here, I think have also exercised a good deal of influence. Organizations like Fair Trials, I think, have played an important role in this. I think also that some of the problem with Interpol arose because of the factors that I mentioned, that they did not intend to create a system of electronic communications which could facilitate abuse. They created a system of electronic communications that ended up facilitating abuse because they genuinely wanted to be more efficient. They weren't doing it because they had bad motives. They just didn't think it through. And I think that they were caught off guard and then unfortunately made the problem worse by denying it over the course of Mr. Noble's tenure. And the arrival of Mr. Stock offered the opportunity for a new broom to sweep a little bit cleaner. Now, I don't want to appear unduly optimistic because the fundamental problem remains. When you're doing 10,000 notices a year, the idea that you can look at every one of them individually is simply a non-starter. There is too much. But some of the problem was unintentional, and some of it is the problem that once you start going down a path, organizations and individuals are always very reluctant to admit that there are problems. So I think the remedy, to the extent there is one, is more sunlight, more exposure, more publicity, more precedent by the CCF, more data publication by Interpol, and continued pressure by organizations like FTI, like Heritage, and in the mainstream media. I don't think anyone on this panel thinks Interpol is a bad organization or thinks it should go away. I would argue, on the contrary, that cooperation between the law enforcement organizations of law-abiding nations is a positive duty incumbent upon civilized states, but not for the purposes of facilitating political abuse.
Well, you're right. We're not out of the woods. I'm still on Interpol, so Kamila?
Thank you. I must say that I totally agree with my colleague with what Ted just said. I also think that it's it's a unity. It's the multiplicity of all these new factors or old factors that have been repeated and have always been there, thanks to practitioners, thanks to human rights organizations. And I think that if the same arguments whirl around, just keep coming back before the CCF, they may start listening or hearing. I think that in certain cases like Yukos, there has been definitely a resisting attitude on behalf of the CCF to withdraw the red notices for the past few years. But then, a number of reports, a number of decisions on behalf of national courts who deny extradition, the ECHR favorable decision, the Hague Arbitration Award, all these international courts all saying the same or pretty much the same. It just creates, a necessity of consistency of legal order to which Interpol is, of which Interpol is part, and in the name of this consistency, I think the CCF has taken some favorable decisions for some Yukos-related individuals. Now, more globally, I think that some reports, especially the repeated reports of the Organization for Security and Cooperation, and before the panel we discussed the Istanbul resolution. A year before, I think it was in Monaco resolution, and last year it was in Baku. So the last 3 or 4 resolutions, they have all repeatedly mentioned that the abuse on behalf of certain states, and as Alexander mentioned, the states that were just there, these abuses have been so flagrant that something needed to be done. And I think this maybe conscious of being criticized all the time makes also CCF and the General Secretariat more attentive. I must also say that the Bill Browder's case was, I must agree with Ted, it was definitely a very important move in the history of Interpol. Mr. Mikhail Khodorkovsky, that you all know, who I represent, he once there was a problem this year in relation to his dorming criminal case, which is called the MBK3 process, MBK3 trial. As you all know, he received some threats via Twitter, etc. And after that, he asked me to do something about it. And when I discussed this question with Bill Browder's team, they told me, why don't you just write like we did on a preventive basis? But you don't write to the CCF on a preventive basis, and there is nothing really to do on a preventive basis. And I was a bit reluctant in the beginning. I said, no, it's going to draw attention, it's obvious that you haven't killed anyone, so just disregard the threats on the Twitter. And they said, okay, well, let's do something about it. And I ultimately did something, and I followed Bill Browder's colleagues, lawyers' advice, and I actually did exactly what they did. I wrote to the General Secretariat saying, on a preventive basis, just writing to let you know that my client has been receiving threats via Twitter. And what I mean by threats is, the General Prosecutor of the Russian Federation publicly stating that he's got blood on his hands, etc. So maybe And there was something in the message in the Twitter that I drew the attention of the General Secretariat. The message said that, and no matter where he lives, that will not stop us from bringing him back. And if this is not the threat of the Red Notice, I mean, I don't know what it is. And the General Secretary took 2 months to respond. They wrote a very nice letter back saying that, which actually I think Bill Browder was a pioneer, and thanks to him we had that letter. They said, well, a letter in French saying, well, dear advocate, thank you for writing to us in relation to your client's matter. We are aware of the abuses that are going on, but thank you for writing to us. We will definitely consider the matter, the Red Notice request, with a lot of attention against Mr. Mikhail Korogovsky if such request was filed. So I was quite happy. We never get such explicit letters from the CCF. So when you get that from General Secretary, you almost want to, to frame it and put it on your wall. So I think that, this constant pressure and general, emerging consensus and a huge pressure that there is around, on Interpol definitely plays a role. And once again, it is an ensemble, of all these factors that make Interpol realize that it is a part of the international legal order.
Thank you very much. I'd like to open the floor for the questions for the floor, if anybody has any, because I have a couple of others if you don't. Yes, go ahead, please. Certainly.
I've been working on the Interpol issue for quite a while now. I represent a client who I will also not reveal the identity of my colleague, Stanley. It's very fortunate in the sense that he spent more time waiting expedition, almost 5 months, because he was a subject of the Interpol notice and at the same time refugee. Now that happened before the Interpol recently adopted this new approach to refugees that they would automatically, totally apply to strong state, that they would remove information about person to person to refugee recognized by the country. With all the suggestions that have been expressed, I have to say that I really do not see how, even if reasonable that having seen rules to jurisdiction of any particular country, Poland, it will actually work out. The reason for that is because the information that's placed in the database is not really placed by the Interpol, it's placed by that country. And the Interpol state that the information is the property of the country that placed it into the database, and that's when we started with the southern state. So if, say, France or the United States enters a judgment against the Interpol, they're really not going to enforce it. They really don't think that's ever going to happen. What I do think might be done is if the CCF, files, has a mandatory real hearing, due process, which now they have the right to give a person who is subject to the Interpol notice for what's worse than confusion, which doesn't even go through a process of this very formal review, unlike Red Notices. And I have to say that the statistics, and if you look at statistics that the number of diffusions is way higher than the number of Red Notices. It's so much easier to place it in the database. If they actually granted a hearing to every person who complains appeals to Red Notice that was placed against the person, that would be way more useful. And especially, in my humble opinion, it's not going to make the life information part too hard, because again, the own statistics that the number of people who feel those differences is really small compared to all the differences of Red Notices that's in the database. I'm sorry, I do not remember the number at this point. I looked at it a while ago, but I believe it was somewhere around 1%. Currently, again, it's just an optional hearing, and the CCF has the authority when it's granted. That's very unfortunate. The due process is very important there. That's what I'm really seeing.
Thank you for that. I just wanted to add to my fellow panelists. I think the fact that we are discussing this today, the fact that we've started sharing information, it used to be something to be ashamed of to be on the red notice. I'm actually quite proud of the fact that the Putin regime put me on the red notice, as I'm sure my fellow other red notice holders are as well from that regime. But it was like the victims of abuse who would hide in shame. No, we're no longer hiding in shame. We're sharing information. We're helping each other. And actually, I wanted to give an opportunity to a representative of Fair Trials International to say something, because it is thanks to your report and your actions with Interpol that we've gotten this progress. So, take my seat.
Okay, it's really kind. Thanks. There's not much time left. I had wanted to tell you all about one of our cases of a Moscow-based activist you may know called Petr Silayev, who was a refugee granted status by Finland, arrested in Spain. Eventually, Spain rejected his extradition, but the red notice remained despite his status, despite extradition being rejected. And initially, our application was also rejected with no reasoning, as is typical from the CCF. And then a year later, they changed their mind after further submissions from us, and pointedly after a large media campaign and the publication of our report on reform of Interpol Red Notice system, they did decide, again with no reasoning, to remove the red notice. So that's really, exemplary of what we're dealing with at Interpol, and a sort of exemplary Russian case for you. Now, Petr's case nowadays wouldn't pose much of a problem because of this new policy we have of removing red notices for recognized refugees. That doesn't affect everyone, and it's problematic for people who have ongoing fear in the country of origin. They may be afraid to even make a submission because there's communication with NCB in the country of origin, and there's also a time lag because there needs to be confirmation of the asylum grant in the country of asylum, and they sometimes don't want to do that for confidentiality reasons. Anyway, so Petr's case, we have submitted several applications after the announcement of this new policy, and they're going away. They're getting deleted very quickly with very minimal submissions. So that's just a practice tip for you all who are dealing with recognized refugees, which I know not everybody is. So in some cases, yeah, refugees have it easy, right? Not really, but in this case, we do see improvement. I just wanted to talk a little bit about some of the reform processes that are ongoing within Interpol and within CCF that you may be able to contribute to, that we're contributing to at Fair Trials. There is a working group on the Committee for the Control of Interpol's Files, the CCF, to look at reforming its practices and procedures. We've given evidence to it. We're about to make a major submission to it, which we'll publish when we do, and that they're going to make a report in 2016. So that's going to be a really telling moment in the history of reform of Interpol Red Notices, and there is space for submissions for those of you who have recommendations for how procedures and practices at the CCF can be improved. We've seen some indication of improvement already. The new chairperson of the CCF is a former European Court of Human Rights judge from Croatia. She has competence in human rights, which previously there was no one who had competence in human rights. They're now meeting 12 days a year instead of 6, so that's good, and they are trying to respond faster. I'm speaking fast because we're running out of time. I hope you can slow down the webcast later and understand what I'm saying. And they're saying that they're trying to provide more reasoning in their decisions, although it's minimal still, and responding a little bit more quickly. Anyway, there's a public acknowledgement that there are problems and that they're trying to fix them. You can look at the most recent speech of the CCF on behalf of the CCF chair at the General Secretariat meeting in Rwanda just 2 weeks ago, where they make mention of all of the reforms they're undertaking. There's talk of a pause mechanism before the issuance of a red notice or diffusion, which is a big mystery. We don't know exactly what that consists of, how long the pause mechanism lasts, and what the compliance check is, but there's an acknowledgement that there needs to be a beefed up compliance check before publication. And there's also been mention of a repository of practice to be published in relation to Interpol's obligations, human rights obligations, which is something that Fair Trials has called for because we don't know what they're talking about with the predominance test, because there's real questions about how they're dealing with their obligations under the Convention Against Torture, about which we're giving evidence to the committee soon, and so we're hoping for more clarity on their thinking soon. To be honest, I doubt they have developed policies up till now because they simply haven't had the competence to do so. So if you want to know more about what's going on, because there's a lot, it's in flux, massively in flux, both in the General Secretariat and at CCF at the moment, and there's a huge possibility for reform. So feel free to contact us. There's a huge amount of information on our website, and you can watch a video about Petter on our website too, and also read our submission and CCF's one-pager responses to us.
Thank you. Thank you. Thank you very much, everybody, for attending. Thank you, my fellow panelists. Enjoy the rest of the day.